What laws did Adams break? The New York penal law and corresponding federal laws define public corruption as anyone in public office taking state property through fraud. Now, if you take more than $100,000, it's a Class B felony in New York. Adams is alleged to have used straw donors to gain more than $10 million from matching funds given by New York State. In New York, when a public servant solicits a benefit with the understanding that it will influence the public servant's vote, opinion, judgment, action, decision, or exercise of discretion, it is bribery. Bribery is always a felony and depends on the amount of the bribe, whether it's a Class A felony. Unlawful gratuities, now that's another law, is when any benefit is given a public servant for official conduct that he is not entitled to additional compensation for. So federal law, which is the U.S. Attorney's Office, is the same as New York State penal law. Some laws apply only to federal officials, which Adams, of course, is not. But the Hobbs Act prohibits demanding payment in exchange for official acts. And it applies to federal and state officials if there's an effect on interstate commerce, which there always is. It's a federal crime for a state government agent to fraudulently obtain property worth more than $5,000, such as getting matching funds by using straw men, or to solicit anything of value intending to be influenced in a governmental transaction. That's another law. The Honest Services Wire Fraud statutes make it a federal crime to defraud anyone of money using the post office or wire services, which would include Adams submitting straw man donors to get matching funds. That's another law. The Travel Act makes it a crime to conduct any unlawful activity, such as bribery or fraud, using interstate facilities. That would include emails, text messages, mail, or wire transmissions. So that's another law. These public corruption cases don't just involve high-level politicians, by the way. Public officers like police officers, judges, witnesses, court employees, municipal code inspectors, all have been charged with accepting bribes. The New York Penal Code prohibits offering money, tickets, dinner, or anything else to an employee to influence their conduct. For example, offering $200 to a Con Ed employee to expedite installation of a gas meter is commercial bribery, a misdemeanor. If the bribe is for more than $1,000, it can be a first-degree felony. And if the employee solicits anything to influence their conduct, it's also bribery. Bribes have been found where an employee gives insider stock information, or information about other contract bids, or names of personal injury clients at a hospital. The employee could be the clerk, or it could be a company CEO. Anytime an employee is in a position to give favorable treatment to someone else, they're the target of bribes. So, what has to be proven to establish a bribe? There are essential facts which must be proven beyond a reasonable doubt, and they're not easily proven. Bribes are rarely articulated. They're done with a wink and a nod in private. Nowadays, there are text messages that cannot be destroyed, which makes it a little bit easier. That's why the U.S. Attorney is seizing all the telephones of people in the Adams administration. The case must prove there's an agreement or understanding that the gift will influence the employee's behavior. Case will be dismissed if they can't show this understanding. It's necessary to prove a person's subjective mental state to show that the benefit would influence behavior. And you got to prove that beyond a reasonable doubt, and that's a rigorous standard. To show you how the courts interpret this, in one case, a defendant passed an envelope in a bathroom containing $3,000 to a union official. No words were exchanged, but the understanding was that the bribe was to keep the union official from raising complaints on the job. The union official was wired and cooperating with the prosecution. The trial court convicted the person who passed the envelope of criminal bribery, but the Court of Appeals reversed, finding there was inadequate proof that the defendant who did pass the envelope, that he knew of the agreement, or that he intended to influence the officer, or that he even knew there was money in the envelope. He could have been a blind mule, they said, an unsuspecting courier. So there must be proof that the defendant knew the money being exchanged was for an inducement to an understanding that it would affect the behavior of the recipient.